Good afternoon, and welcome to the Kansas Supreme Court. We have one case set for argument this afternoon. As a little background for those who might be listening in and not familiar, the case we hear today is a little different from the typical appeal that we hear from another court or an administrative proceeding. Today, we have been asked to hear a case that was originally filed with our court. The Attorney General has argued that this action falls within a small group of cases that fits within this court's Article 3, Section 3 grant of original jurisdiction. This case was filed a mere 17 days ago, and during that 17 days, the parties had requested expedited proceedings, and we did grant that motion, and in part at least, and set a tight briefing schedule, and also asked the parties to attempt to present to us stipulated facts to frame our legal issues that we would consider. I want to just take a moment to express the court's appreciation to counsel for their cooperation in accomplishing those tasks and giving us a stack of materials to prepare us for the arguments today. With those introductory remarks, I will formally call the case 121061, State of Kansas ex-rel Derek Schmidt, Attorney General's petitioner, versus Governor Laura Kelly in her official capacity, Chief Justice Lawton R. Nuss in his official capacity, and the Kansas Senate as respondents. Would counsel please rise and state your appearances?
Your Honor, the State of Kansas appears by and through Derek Schmidt, Attorney General, and Dwight Carswell, Assistant Solicitor General.
May it please the court, Clay Britton on behalf of Governor Laura Kelly.
Steve Big and Sam Green for Chief Justice Nuss.
Your Honor, Jeff King on behalf of the Kansas Senate.
Thank you, counsel. For obvious reasons, given the fact that you've just heard me read the Chief Justice's name and have heard the entry of appearance by his counsel, the Chief Justice is recused in this matter, has not participated in any of the scheduling, the planning, or any of the discussions that the court will have regarding this case. Sitting with us in his place is Senior Judge Mike Malone. Thank you, Judge Malone, for doing that. With that, counsel, are there any preliminary matters that any of you wish to present to the court before we begin argument?
No, Your Honor.
No, Your Honor.
No, Your Honor.
None.
All right, thank you. With that, General Schmidt?
Justice Lukert, and may it please the court, with permission, I'd like to reserve 4 minutes of my time for rebuttal.
4 minutes is reserved.
Your Honors, this is a most unusual case that arises from a most unfortunate series of circumstances. The state's interest in this matter is in timely obtaining a definitive answer as to who, on these facts at this point, is now the proper appointing authority with respect to the vacancy on the Court of Appeals created by Judge McEnany's retirement. There are ancillary questions that flow from that depending upon how the court answers that question, but ultimately that is the state's interest so that there will not be a cloud hanging over whoever the next judge on the Court of Appeals may be. With that, 4 different options as to what the correct answer to that question have been presented to the court by the parties in the briefings. I think one, at least from the state's vantage point, can be disposed of quickly, so I intend to just mention it and then move on unless the court, of course, sees it otherwise. And that's the option that perhaps Judge Jack's nomination remains pending in the Senate, and therefore the clock for Senate action or deeming of confirmation is ticking. We would stand on our briefs on that question. We think the withdrawal statute is plain, that the governor's withdrawal of the nomination of Judge Jack was properly effectuated, and that it is not pending before the Senate.
Counsel, you did address that statute. I don't recall, maybe you correct me if I'm wrong, in your briefing that you addressed the question of whether or not, factually speaking, the statute was actually triggered. And what I'm driving at is the statute talks about the appointing authority withdrawing the nomination. Did that happen here?
Your Honor, the parties have stipulated to the specific acts on or about the 15th of March that led the delivery of the paperwork from the governor, for example, to the Senate Majority Leader's office, and I don't think that is in dispute.
Well, I have the stipulation, and as I read it, for example, paragraph 5 says Judge Jack submitted a letter to the governor withdrawing his name, and Governor Kelly submitted a letter to Senate Majority Leader Denning that Judge Jack had withdrawn his nomination. And the actor in both of those pieces of correspondence is Judge Jack.
Well, except, Your Honor, you're correct. Those were the two letters that were submitted, I think, the third and fourth day after the Friday appointment. My recollection of those is that Judge Jack's letter to the governor said that at your request, speaking to the governor, I'm withdrawing, and the governor's letter to Senator Denning was a message from the governor to Senator Denning indicating that
that's
he
just
was
the
withdrawing
question.
at her request.
Is the appointing authority's request to the nominee to withdraw his own name sufficient under the statute?
Your Honor, I think obviously the parties didn't brief that question, but my response to that would be that on these facts as they're stipulated, the governor actually did withdraw Judge Jack's nomination when she communicated as herself to the Majority Leader of the Senate that the nomination was withdrawn. Admittedly, she said that Judge Jack had withdrawn it at her request, but our view is that's functionally the governor withdrawing the nomination.
If we disagree, does 754315B, A and C apply if it is the nominee that withdraws?
I think the language of 754315, the pertinent sections you talk about the appointing authority withdrawing the nomination. They do not talk about other forms of withdrawal or perhaps a successor to the appointing authority in the event you had a different. So
my follow-up question is, if we determine that the statute you're relying on is not applicable because it was the nominee that withdrew, then why isn't Judge Jack's appointment pending? By what other authority did the governor have to withdraw the appointment that the statute says is effective when made?
right. I understand the question, Your Honor. Of course, the state does think that statute applies, but I understand what you're positing. I think our view on that would be that there is no express statutory authority other than 4315B that provides for a withdrawal. And in fact, if we get to that, the fact that there are express statutory authorities providing for withdrawal in other analogous appointing circumstances, for example, a district court judge or members of this court after a nominating commission has sent a name up and then brings it back. We think that's pertinent to our argument on why the statute is silent on the fundamental questions that we can otherwise address.
And because
I'm sorry, I would say, and I have not researched it, Your Honor, because I hadn't anticipated this would be where we'd be focused, but I do think that in the sort of general case law, the notion that an appointing authority may withdraw their appointment prior to it becoming complete by confirmation or whatever the final action is, I think that is generally accepted in the case law, but I can't point you to a case right at this moment.
And that was going to be my kind of the focus of my question, which was the fact that the legislature has adopted this statutory scheme of appointments and withdrawal of appointments. Have they occupied the field and displaced any common law of an inherent, if you will, executive power to withdraw?
I think, Your Honor, I don't know that they've occupied the field. They have at least displaced common law that would conflict with the statutory scheme that they've adopted. I'd have to think a bit more about whether they've fully occupied the field. I'm not certain if that's the case or not. But certainly to the extent there's a conflict, yes, the common law would be preempted.
General, I have a kind of the same question, but was Judge Jack required to withdraw? Or does his withdrawal, short of some type of criminal compulsion or whatever, an act on his own without the governor requesting it? In other words, was he compelled to withdraw because she asked him to?
Your Honor, I don't think so. I believe it would be the case that, at least as a general matter, that a nominee or an appointee, simply because the nominating authority requests withdrawal, is not obligated to do so. Now, the appointing authority may be able to withdraw the nomination with or without the acquiescence of the nominee. Sort of back to my
Doesn't
point
that
on-
answer suggest that in fact Governor Kelly never did withdraw this nomination?
No, Your Honor, I was just going to say, I think it actually confirms what I was attempting to express as a point of view in response to your question, because I think ultimately the act of withdrawing is the act of the nominating authority, not the act of the nominee, regardless of whether it's requested or acquiesced to by the nominee or not. The authority to appoint is vested in the appointing authority, and the authority to negate that, so to speak, by withdrawing is...
How do we know what Governor Kelly would have said had Judge Jack said, I'm not going to withdraw?
We, of course, don't, or at least I don't. Perhaps, Governor Kelly, who's represented through counsel, can speak to that. But I think, in a sense, Your Honor, it's immaterial, because the act of Governor Kelly saying to the Senate Majority Leader, this is being withdrawn, was enough, since she was the appointing authority.
Here's the problem I've got, and it's kind of, I hate compound questions, but it's got two parts to it. The biggest problem I've got is that when you look at the old nominating commission statute as it applied to the Court of Appeals, it had provisions in it that dealt with withdrawals. And so we know the legislature understands how to do that, and it didn't put that in the new statute. So that kind of suggests to me that there's a good strong argument that there is no right to withdraw, which then gets you over to, which tells me you have to have 75-43-15 or you're dead from that perspective. And the general statute, this is a general statute and not a specific one, and the Court of Appeals nomination statute is specific. So under our statutory interpretation rules, the specific overrides the general. The specific doesn't have anything in it, but the specific used to have something in it when it was in the old setup. It just seems to me we can't be reading words into statutes, and I'm really kind of surprised you guys are up here wanting us to do that.
Well, Your
We
Honor,
normally don't want us doing that.
and in this case, Your Honor, the state doesn't want you doing that. To the extent the court chooses to reach the merits of other parts of this case, the state's position is you shouldn't read words into the statute that aren't there. On this particular one, and I do understand, recognize, there may be an argument that 6 of one, half a dozen of the other, but it does strike me that this is different with respect to the withdrawal issue than, for example, the silence of the statute as to who gets to appoint next, which is the substantive core of the argument, assuming that there is a vacancy that doesn't have Judge Jack currently pending in it. And the reason for that is that we do have the other statute, 4315. The court's general guidance and statutory interpretation is to read statutes in harmony if they can. In this case, there is no conflict between the general statute, 4315, and the silence on the subject of withdrawal in 2030-20. So we think they are properly read together harmoniously. Now, the issue, of course, is we started with Justice Stegall, whether or not the provisions of 4315 have been triggered, because they, of course, contemplate the governor, in this case, making the withdrawal as opposed to the nominee. As I was trying to explain before, I think it's the same thing. The governor actually did withdraw this nomination. She is the one who communicated to Senator Denning that the nomination is done, is withdrawn. The fact that she said it was because she had asked and Judge Jack had acquiesced and said he would withdraw is beside the point. Judge Jack didn't contact Senator Denning and say,
Does our decision in Kobach or Taylor v. Kobach have any bearing on this? And that was, just to refresh, that case dealt with some very similar facts with different statutes, but it was a letter that purported to effectuate a withdrawn nomination, and the question was the letter sufficient? And we more or less said we only look at the plain language of both the statute and the letter.
Yes, you did, Your Honor. As I recall, in that case, you concluded that it was sufficient, even though the language in the letter, the plain language, didn't articulate the standards
The
of
letter
the
said
statute. It just said pursuant to this
to the
provision.
statute. And this letter doesn't say that.
It's true. It does not. But nonetheless, I think that what happened here was that the governor withdrew this nomination. And I think that's what's authorized by 4315B.
Counsel, I know you're struggling to get to the merits of the meat of the issue here today, but I want to back you up one step further for just a moment. And that is what we have at the time of withdrawal. Did we actually have an adequately pending appointment at that point, given I think there's very lawyerly language in the stipulated facts, and your briefing has indicated, well, these are the facts, the legal effect of them is for the court to decide. Is that still your position? What does the state have a position on whether the nomination or the appointment was made by the governor in 60 days?
The state accepts that that did happen,
Okay.
that it was sufficient when the paperwork was delivered by the governor's office to the Senate Majority Leader's office and slipped under the door as requested or advised by the Majority Leader's staff. We accept that that was sufficient.
Okay.
The only reason, not to weasel word it, but the only reason I hesitate on that at all, I do think there is arguably a question in the statute, because one clock stops running when the governor makes the appointment, and the second clock for Senate action starts running when the Senate receives the appointment. And I can imagine a
Your initial
circumstance.
pleading said that was
Yes.
a hole.
I
But
can
that's not
imagine
the
a
gap you're talking about
circumstance
anymore.
that is a hole,
Okay.
but I don't think it's a hole that applies here
not the
based
gap
on the
you're
facts as
relying on.
stipulated.
It's not
Correct.
the gap you're relying on.
Correct.
Okay, thanks.
Correct.
Let me move you to this lawsuit. I'm troubled by this being an original action in quo warranto, and frankly not quo warranto and mandamus. You chose to do it as a quo warranto action, and I really can't figure out how that was an appropriate way to frame the legal issue at the time you filed it. I can fix it later with the Sarah Warner appointment because there's an action there. But I don't see how this is an appropriate quo warranto action, particularly as it relates to the Senate, which hasn't done anything.
Well, Your Honor, a couple of thoughts on that. Number one, our thought process was that what's being questioned here is the authority of the three actors, or any one of the three actors, the chief, the Senate, the governor, who are the three acting parts, if you will, under the statutory scheme to effectuate an appointment and confirmation. We were questioning their authority to do so, to proceed so, to claim the authority to act as the statute contemplates. At the time we filed the lawsuit, the governor had taken initial action. Obviously, she'd appointed Judge Jack and then withdrawn him. And beyond that, she had indicated upon withdrawal her intent to appoint another person within the 60 days. So it was apparent she was proceeding. The Senate likewise had received, a response to this question over here, had received and apparently given up, if you will, the appointment of Judge Jack that had been sent up and back. And the Senate had questions as to the ticking of the clock, the one we spent so much time talking about already today. Is Judge Jack's nomination out or not? They later raised them in some of the back and forth paper, but they had questions on whether or not it was still pending. That's point number one. Point number two, I take your point about ought we to have posited this as an action in quo warranto and mandamus. I think quo warranto is sufficient. I recognize the governor's briefing, for example, raises the question of whether it was more appropriate as mandamus. I don't think it was more appropriate, but I certainly acknowledge mandamus in addition could have been appropriate. I don't think that's fatal. It presents the same question. And finally, in the event Your Honor needs a saving construction on that question, I would note that we pled and asked for such other relief as the court deems proper. That was in the state's petition, and in the event you think mandamus relief is more appropriate, we would welcome that as well. We just want an answer.
Well, but we're not allowed to give advisory opinions, and so we've got to have something real in front of us. And here's the quo warranto statute that I'm focused on, and I don't see how it applies to the Senate at all. So the statute says that quo warranto may be brought in the Supreme Court, quote, when any person shall usurp intrude into or unlawfully hold or exercise any public office or shall claim any franchise within this state or any office in any corporation created by authority of this state. Close quote. I just don't see how that applies to the Senate. They haven't done anything. They're sitting around waiting for the clock to run out and hoping that they don't end up with Judge Jack on the Court of Appeals.
Well, actually, Your Honor, respectfully, I think they have done something. I'm not their counsel, I'm not privy to their, but they have made a decision with respect to whether or not they would have acted on Judge Jack's nomination, for example, prior to their first adjournment that just occurred. They've made the decision to insert in the adjournment resolution, which is attached to one of the pleadings that was filed here, a very unusual provision that allows the Senate but not the House to come back into session. I think it's on May 14th, might be the 15th, whatever that date is, for the purpose of dealing with Judge Jack's nomination. So the Senate has engaged in actions.
Well, they haven't
somewhat
had from
unusual.
the time you filed this lawsuit, but let's focus on that. Why don't we just let them act, and then we can all go home? Because that takes care of this whole problem. They vote it down. It's not unusual. I mean, in Leak versus Tice, Governor Bennett told the Senate to kill the old docking appointee, and they went and did it. And we didn't have all that, but if it really does kind of counsel, and in fact that you said that, it really does kind of say that we ought to just dismiss this lawsuit and let them go do it on Tuesday or whenever, and then the statute does kick back in. There was no consent. The governor gets to do it again, and you're off to the races.
Well, I'm not sure about that last part, Your Honor. Let me maybe play that out a little bit, if I may. I mean, even if I'm not sure that the Senate voted. Let's assume, for example, that the court dismisses the lawsuit. The Senate votes down Judge Jack, whether or not he's actually pending. It would be odd to ask the Senate to cast a vote when there's no determination whether the matter is still pending, which would be where we are if you dismiss the lawsuit without a ruling, at least on that question. But setting that aside,
They could change their position. I mean, in theory, it's only the Senate's position that's in agreement with you on authority for withdrawal that makes the nomination no longer pending.
and it's the governor's position as well.
Yeah, I know all the parties want us to do this. We fully understand that. But it is kind of, you are in a funny place because you are going,
Oh, I don't disagree with that.
Don't restrain yourself
Yeah.
here, but please restrain yourself over here. It's kind of both sides of your mouth.
We're not trying to ask the court to manufacture a statute with respect to the withdrawal. And if that's what the court thinks is necessary in order to conclude that Judge Jack's nomination is not pending, then I'd quickly say, please don't manufacture a statute in order to do that. That's not what the state is asking. What the state is suggesting is you don't have to manufacture a statute because there is one, 4315.
One of the things you didn't mention earlier is that we assume the legislature knows law when they pass legislation.
True.
So even if they were not subjectively aware or didn't know the ins and outs of that statute, the statute was on the books and they're assumed to have known what it said.
Also true. Of course, you're right.
Another reason to read them in harmony. I get that.
And we get to construction rules because there's silence, and we've said silence is an ambiguity. And if the statute's ambiguous, we can get to construction rules, correct?
Well, I don't think so, Your Honor. I don't think there's a need for construction here actually at either point, either the withdrawal issue or later on what I'll refer to as the merits. In this case, there is a statute that contemplates withdrawal, as I suggested to Justice Stegall. We think on these facts it is triggered. There's nothing ambiguous. There is no silence. That statute applies is our position, and therefore that nomination is withdrawn. Likewise, later on the merits, which we've not talked about, the other merits, which we've not talked about yet.
But if we have to go outside, then we have some, it's not explicitly stated in this statute, and so we have to construe this statute as incorporating 75 whatever. And if we get into construction, then we have a construction rule that says we don't read a statute as being meaningless or absurd. And my question is, we have a statute that's designed to provide for filling a vacancy on the Court of Appeals. And you're asking us to find a legislative intent to make a vacancy incapable of being filled filled under a circumstance that is easily foreseeable. I mean, this isn't a rarity that appointments are withdrawn. I mean, it's not a weird circumstance. It's easily foreseeable, and you're asking us to construe a statute that's specifically designed to fill a position as not being effective to do that.
Yes, of course, Justice Johnson, I am.
In a easily foreseeable. Why isn't that absurd? Why isn't it absurd to construe a statute designed to accomplish something, to say it can't do so in this circumstance?
Quite to the contrary, Your Honor. I think this is why. I agree with Your Honor that withdrawals happen. It's relatively common in the world of appointments, whether it's judicial appointments or other appointments. It certainly is foreseeable that withdrawals might happen. And yet, in this case, knowing that, and not only knowing that, but knowing that the prior statute that was repealed with the nominating commission here had an express provision in it regarding what happens if there's a withdrawal after the names have gone up for the nominating commission and the Chief Justice's clock resets, if you will, based on that. They didn't carry that forward into this statute. They made no provision in this statute for this circumstance. It was foreseeable it might arise, and yet they didn't speak to it.
So
I'm not trying to tell you that the legislature intended this result. I'm just telling you this is what they did. There's obviously a disagreement between the legislature and the Senate on what they would have done if they'd addressed it, and they shouldn't invite this court to fill in that policy.
You're out of time, General, but speak to the relief that you're seeking. You're seeking us to just say, do nothing? I mean, what are you asking us to do?
I'm asking.
And if it's do nothing, how is this even justiciable? You seem to jump over the Baker versus Carr factors, but I don't see how this is justiciable in your mind if you're asking us to do nothing.
Well, we think there's a live controversy because we have the governor attempting to make a second appointment. That's obviously in conflict with, in the event the court were to find, or somebody were to find, that Judge Jack's appointment is still pending. You can't have two pending at once for the same vacancy. It's certainly in conflict with the Senate's view of what the state of play is, and the Senate then will be asked to decide, perhaps without guidance from this court, in the event the court were to not rule, whether to vote on Judge Jack, whether to vote on the second appointment, which timelines might apply. I mean, it is a live controversy that the public official needs some guidance on, and both quo warranto and mandamus have been invoked previously. This court's recognized that as a legitimate reason for the court to act.
Well, how is that us not legislating a cure?
Well,
aren't you asking us to do that?
No, quite the contrary, Your Honor. There is a statute upon which the parties are relying. It's a statute that two of the parties created, or at least their predecessors in interest did. They enacted it. It's a statute that governs them, their conduct, the Senate and the governor. It's a statute they can change and amend, and yet there is a circumstance here that in the state's view was never contemplated. This withdrawal after the 60 days and then the desire to have a second bite at the apple or a subsequent appointment. And they have opposite and non-reconcilable views on who gets to make that second appointment. All we're asking as the state is for the court to say that, if you agree, that this statute doesn't answer the question that they've got in front of them. That's it. The court construes statutes all the time. It doesn't answer that question.
And you're not asking us to legislate. You're not asking us to fill the gap.
No. In fact.
So then what happens?
Well, at that point, I think you have a statute which is still valid. I mean, if there were another appointment, for example, if another member of the Court of Appeals were to create a vacancy later, the statute's valid.
What happens?
This one is then caught in limbo. And I think at that point, and by the way, this one is going to be caught in limbo until somebody fills the gap in the statute.
That's your position.
Yes, and I think it's correct. The Senate and the governor would like this court to fill that gap in the statute. The state's position is they ought to fill that gap in the statute, and we think that's the better posture for this court to be in. If there are no further questions, Your Honor,
I'm sorry.
I'm glad to stay.
Just kind of a reverse on that. We talked about what's not in the statute, but can you imagine the legislature having to add language requiring or limiting, restricting a non-partisan, a judicial appointee from being able to change his or her mind or a change of circumstances? In other words, does language need to be in the statute for the appointee, before he's being or she's being considered consent by the Senate, does there have to be, could the Senate or the legislature even put language in there saying, no, you can't do that, you can't withdraw?
Well,
Without first going before the Senate. I mean, this is a citizen. The governor has a position, but this person is just an appointee. Why couldn't that person withdraw before consent by the Senate with the language being completely void in the statute? Is there a free will argument there?
No, Your Honor. The state's position is not that the nominee cannot withdraw, or at least not that the nomination cannot be withdrawn. That's the issue with respect to Justice Stegall. That's not the state's position. The state's position is once that withdrawal occurs, what happens next? And the statute talks to that in great specificity. In the event that, I shouldn't say the withdrawal occurs, but in the event, for example, there had been a Senate defeat of the nomination, then the statute specifically says 60 more days the governor makes the next appointment. In the event we hadn't gotten to the nomination in the first place because the governor had missed the initial 60-day deadline, the statute speaks to that. It says the Chief Justice makes the appointment. In the event they still don't get it after a round or two, the statute speaks to that. The same process is to be used again, time and again. In the event the Senate receives the nomination or appointment but simply never acts, the statute speaks to that. That's the last sentence in subparagraph B on 2030. Then there's the deeming of confirmation. This is a circumstance that was foreseeable. You have a withdrawal, you have what the state calls a failure of the nomination on the merits for a reason other than the Senate voted it down. The nomination failed because the governor withdrew it. And the statute doesn't speak to that. And because the legislature spoke to many particular circumstances but didn't speak to that one that's foreseeable, this court shouldn't fill that gap. There's obviously strong policy feelings on what the answer should be. They didn't answer it. They wrote the statute. They could have answered it. The role of this court is simply to say, if you reach it, which I hope you do, you didn't answer it. Doesn't apply here. We've got a dead end, and that allows them to go back and act again. We're not asking you to order the legislature to fix the statute. Just say the one they wrote doesn't apply here. They'll react however they choose to react.
I wanted to make sure you had a chance to finish your answer, or if you did finish your answer, then I need you to repeat what you said in relation to my question about if we just dismiss this and the Senate goes ahead and acts on Tuesday. I understood you to be saying that there's still going to be a problem, and I wasn't sure what that problem is, because in my mind they vote it down, the governor's back in the saddle and sends another nomination up or whatever, and then they just go about their business.
Your Honor, I think if I understand your question correctly,
I want to know what happens if we dismiss this lawsuit and they vote it down and they vote Judge Jack down on Tuesday.
Then I think the same controversy remains, and here's why. Let me distinguish that hypothetical from a related one, and maybe it'll make my answer clearer. If this court were, for example, to rule that Judge Jack's nomination remains pending before the Senate, and then not reach any other questions in the case, which I'm not asking you to do, but if you were to do that, then I think the answer is, if the Senate, let's say, votes it down on Tuesday, then we know what to do next, because the statute tells us there was an adverse Senate vote. That's the fourth sentence in subparagraph B. The governor then gets another 60 days to make the appointment. The problem in your example, I think, Your Honor, is if this court doesn't answer the question as to whether Judge Jack is pending before the Senate and just dismisses the lawsuit, then whether the Senate, let's just say the Senate votes, there will still not be agreement among the players on what the Senate voted on. Did it vote on the nomination of Judge Jack? Some will say yes, some will say no, because we don't have an answer to whether his nomination is still pending.
It sounds like you're saying, in effect, that a vote on a non-existent nomination could never trigger the second 60-day period.
Correct,
because it's a legal non-entity.
We're still back into the circumstance the statute hasn't addressed.
Which leaves the cloud that you talked about earlier on whoever the subsequent nominee might be.
Absolutely, which is back to what the state has understood this court's teachings on the proper role for exercise of its original jurisdiction in either mandamus or quo warranto or otherwise. One of the proper circumstances is, when a matter is properly presented, to provide guidance to public officials in the conduct of their public duties. It's not an advisory opinion, it's trying to answer the question, who now has that authority? With that, Your Honor, I'd be glad to
Other
stand aside.
questions? Thank you, Joe. Mr. Britton?
Justice Lukert, and may it please the court, I'm Clay Britton, I'm Chief Counsel for Governor Kelly. When the legislature changed the process for selecting Court of Appeals judges in 2013, it intended first to strengthen the role of elected officials in the process and to keep it from stalling. The Senate's interpretation of this statute would result in a weakening of the role of elected officials, and the Attorney General's interpretation would stall the process. That can't be what the legislature intended, and it in fact is not what the law provides. Section 2030-20 broadly authorizes the governor to fill any vacancy on the Court of Appeals and sets out a two-step procedure for seating a new judge. First, subsection A addresses who gets to make the appointment, and it says the governor gets to make the appointment and to do it within 60 days of the vacancy arising. Subsection B then addresses the process for Senate consent, which, as it says, is required before the appointee can assume the office of Judge of the Court of Appeals. So as the governor, the Senate, and the Attorney General all agree, the governor also has the authority to withdraw an appointment prior to a Senate vote. And clearly, Section 2030-20 contemplates the idea that there may need to be more than one appointment by the governor before a judge is ultimately seated. So even if the legislature didn't quite use the clearest language to explain what's supposed to happen after a withdrawn appointment, this court can use its routine tools of statutory construction and interpretation to determine what the legislature intended to happen. In the plain language of the statute, the tools of statutory construction that this court uses often, and the legislative history of the enactment of the statute all point in the same direction. That is, that the governor is able to withdraw that appointment and then also to be able to make a follow-up appointment as well.
This is mainly just a broad purposivist argument, isn't it?
That is what I'm talking about right now, yeah.
Yeah. Do you have something else for us?
Sure.
Because we're not in plain language land, right? Because we have silence.
Well, I
about
think
this particular circumstance.
I don't think we have silence on this particular circumstance. The legislature has spoken specifically to withdrawal through KSA 754315B. Certainly hasn't been silent on the governor's authority to do that. The legislature has not been silent on the governor's authority to make follow-up appointments if a first appointment doesn't result in the judge actually being seated on the court.
I think the wording is if the vote is unsuccessful or something like that, right? If it fails.
And that's correct. The wording is, I think the line from subsection B is, in the event a majority of the Senate does not vote to consent to the appointment.
Right.
And then
So
it
that
goes,
could be does not vote to consent as in never votes, or it could be does not vote to consent because they voted it down. Right? There are two possibilities with that language.
there could be two possibilities with what would be covered by that language, but I mean, there could be multiple possibilities for language of any. I mean, just because language encompasses multiple things happening doesn't mean that the language itself isn't plain or clear. So I think that's the situation we have here.
In fact, aren't you saying that encompasses the circumstance where the appointment's withdrawn?
Absolutely. I mean, if you just ask the question, after a withdrawn appointment, has the Senate, as a majority of the Senate, voted to consent to the appointment? Well, no, it hasn't. So, and now, again, that's maybe not the clearest way to say it, but it clearly falls under the umbrella of those circumstances. But I think it's most important and helpful to probably focus on subsection A, which talks about the governor filling any vacancy. Because the way that the statute actually works and the way it best makes sense is to view the withdrawal of an appointment as creating a new vacancy, in a sense.
So that would be your triggering date for the next 60-day period.
Correct.
But how do we get there when the language of the statute is that 60-day period is triggered by the vote of the Senate?
Well, first of all, I'm not sure that I would agree that that subsection B is necessarily triggered only by a vote, but I think
the language is within 60 days after the Senate vote on the previous appointee.
Right, and that's the sort of third of four potential clauses in that sentence. And I don't think that that is really the operative clause in terms of when the governor has to do something when there isn't a Senate vote. So moving back to subsection A, where we're talking about a vacancy, if a vacancy arises after a withdrawn appointment, then the 60-day clock that applies at that point is the 60-day clock from subsection A4.
Doesn't that just completely defeat the 60-day time limit as a practical matter? I mean, couldn't a governor indefinitely extend by just nominating, withdrawing, nominating, withdrawing?
Well, I think the governor could probably do that if a governor had any good reason to do that. And this is something, sorry, I didn't mean to interrupt.
No, that's all right.
Yeah, this is something we've addressed in the briefing. That there are lots of things that could happen under statutes as written that would make no sense and would be strange. The legislature doesn't have to provide for all of those eventualities. And it seems in this case that yes, if the governor wanted to appoint, as I think the Attorney General mentioned, a token appointee to sit there and not be able to do anything for 60 days, and then appoint another token appointee to sit there and not do anything, I suppose that could happen under the statute. But
your view is that the legislature it wasn't in their intent to prevent that circumstance.
Right, because there's no incentive for a governor to really do that.
Did I misunderstand you to say that the intent of the legislature in passing this in 2013 was to strengthen electorate participation and to expedite the process?
I think I not necessarily to expedite, but to prevent the process from stalling. I think.
So how they're providing your construction that it can be held open through a governor appointing every 59 days or appointing, withdrawing 59 days, appointing. How does that construction fit within what you're arguing as legislative intent?
Well, I think it fits because the legislative intent wasn't designed to address a situation so remote and unanticipatable.
Well, how is that remote? Let's just hypothesize a circumstance where the partisan balance in the Senate hangs on an upcoming election, and a governor hopes to keep a vacancy open for a new Senate to consider. It would seem to me that the language of this statute is expressly geared to prevent that from happening.
Well, I think the language of any statute can't take into account all of the sort of political circumstances that are going to affect the process. Certainly, this one can't anticipate all of those kinds of situations. But the Senate would always have the authority to either consent to that appointment or not consent to it.
Not if it's withdrawn.
Well, that's absolutely true. But ultimately, in Justice Siegel's scenario, I suppose the governor ultimately wants somebody to be on the court and is just waiting for the Senate's makeup to change. But the Senate would always have the ability to vote that appointment down at whatever point it actually comes up for a vote. So that's built into the process to avoid this kind of a situation. And keep in mind that by virtue of strengthening the role of the elected officials, namely the governor, in this process in the first place, those people who are making these decisions are subject to the electoral process. They're subject to make a good decision that's not going to result in the people who used to support them no longer supporting them. I think that's part of the idea of the whole thing, is to have this process be subject to those pressures, which would argue against the kind of gamesmanship that this scenario would entail.
Mr. Britton, does it matter who withdrew for consideration? Was it the governor or was it the appointee? Does that matter in your argument?
Well, I think it may matter as a legal question or an academic legal question, but I don't think it's really a factual question in this case. Well, I think to get to what you're asking, Judge Malone, the statute says that the appointing authority can withdraw the appointment. So if there was some question as to whether Governor Kelly intended and in fact did withdraw the appointment here, then that would be an issue. But looking at the facts, looking at the letter that the governor sent to the Senate Majority Leader, I don't think there's any really reasonable way to read that other than that the governor intended to and did in fact withdraw the appointment.
But
how do you get there?
Since the judge was already appointed, is your position he had no choice but to withdraw, or couldn't he keep in the game, so to speak?
I suppose under the statute, it doesn't really matter what the appointee thinks. It's about what the appointing authority wants to have happen and then executes. So if the governor didn't want the appointment to be withdrawn, presumably she would not have communicated that to the Senate Majority Leader.
But I guess my question is, did he have to withdraw? It's the same as the general.
I don't think that he has to withdraw. I think it's about whether the appointing authority has withdrawn.
How do we get there from the stipulated facts and the documents in the record?
Well, the governor's letter to Majority Leader Denning on May 19th says, at my request, Judge Jack has withdrawn his appointment, and I will
So
submit
we know a request was made from the governor to the nominee, and we know that the nominee chose to accede to that request.
Right.
And he withdrew his own name from consideration.
So
But
maybe
you-
the way to, sorry.
I mean, you just answered Judge Malone's question that Judge Jack didn't have to withdraw. What would have happened had he just said, I am not going to withdraw?
The governor, I assume, could have sent a letter that said, I withdraw this
Right.
appointment.
But the governor also could have said, your choice. Okay, good luck. I'm not going to support you, right? That could have been something the governor could have said as well. Because that's where I'm struggling. I mean, there's a difference between I say to my nominee, please withdraw your name. It's similar to the circumstance of you have an employee that you hope to separate from, and you say, it would be more pleasant for all of us if you would just resign.
I think maybe a helpful way to look at the situation, Justice Stiegel, is to think about that letter as if it were a statute. And let's try and construe the language of that letter to determine what it means. Does it mean that the governor is withdrawing that appointment or not? Let's look at the situation surrounding it. Would the letter have been written and delivered if the governor did not intend for it to withdraw the appointment?
Well, that's what I'm struggling with,
Yeah.
that I don't know. Because that's the factual, that's the fact that's lacking here. We don't know what the governor would have done had Judge Jack said, I'm not going to withdraw.
And I don't know that we need to know that because the governor sent this letter, and I think the only reasonable interpretation of what that letter was is that it withdrew the appointment.
Okay.
In fact, that's what we all agree it effectively did, and the parties have all behaved as though it withdrew the appointment, including Governor Kelly.
Didn't the governor send the first letter or the first notification of appointment?
Yes, she did.
Well, then why wouldn't it be the governor that would convey that the nominee had withdrawn? Why would the nominee make a direct notification?
That makes sense, and that is why the governor did, in fact, make the notification to the Senate Majority Leader.
If she had not requested the withdrawal, she still would have been conveying that to the Senate.
Right.
Right? And so the fact she conveyed it to the Senate, which you've just argued, to me doesn't prove whether it was her idea or his idea. I mean, it wouldn't make any difference. That act doesn't make any difference in my mind.
Right. I think that's true. It doesn't make a difference sort of whose idea it was. What makes a difference is whether the governor acts to withdraw that appointment, and that's what the governor did in this case. May have done it in a way that sounded a little bit nicer than I'm just withdrawing it on my own. The governor did it in such a way so that the Judge Jack was asked to withdraw. He did. The governor communicated that the appointment had been withdrawn at that point.
Seems to me there are several differences between 20-30-20, which is the Court of Appeals statute, and 75-43-15. One of which is the Court of Appeals statute says that when the governor makes the appointment, it's effective at that time. And the general statute says that appointments will be subject to the rules of the Senate, which are that you are subject to their vote whenever they get around to it, where we know 30-20 says if they don't get around to it in 60 days, it's deemed to be consent. Those are real differences, and particularly the appointment being the Court of Appeals judge being effective at that time. And I have trouble with that, reconciling that language with this notion that you guys have that this is subject to withdrawal by the appointing authority when there's not a perfect mesh of these things.
Yeah, well, I think the way to look at that, the effectiveness of the appointment under 2030-20, is two things. Number one, that tells you when the vacancy has been filled by the appointment, so to speak. Subsection A talks about filling vacancies, and that appointment is effective under A6 when you have both an appointment and a then existing vacancy that the appointment fills. So that's it becoming effective. And it's also important for language like that to exist because now we know when the Senate's 60-day clock starts to tick. It's sort of a reflection of the received by the Senate language in subsection B. But the difference, there certainly are differences between that and the broader 754315B statute, because in that instance, the legislature hasn't made its policy known of preventing the process from stalling, keeping the parties moving. So the fact that we have that in 2030-20, I don't think means that we shouldn't also still look to the other statute to provide authority to withdraw. They can work together in that way.
It just seems to me under the rules of statutory interpretation, you're back fighting between the specific statute that deals with this specific situation of a Court of Appeals judge, and then the general stuff, the general appointments where they're subject to Senate confirmation. And I'm really struggling to get past that rule of statutory interpretation, which just tells me that the general rule isn't going to apply to this thing, which then gets you to there's no right to withdraw.
Understood, and I would echo what the Attorney General said on that point. I think if we had a contradiction or a real dispute or a fight, as you just said, between the general and the specific, then of course we would say the specific is going to control over the general. But these two statutes really can work in harmony together and do work in harmony together. And in fact,
do you see a problem if we just dismiss this lawsuit and let the Senate do what they're going to do on Tuesday and then let the statute speak from there?
I do, Your Honor. I think we still have the same questions about this case, and the Attorney General got to this as well, talking about what is the Senate voting on if, in fact, an appointment has been effectively withdrawn. If the court hasn't answered that question and the other questions that we've put before the court, then this next appointment is still going to be questioned, or potentially could be questioned, on that basis.
I think the Attorney General argued that all we needed to do was decide on the effectiveness of the withdrawal in order to prevent that. Do you think we need to go on to the other questions in this case? If we say let me back up. If we say that the withdrawal is ineffective, then of necessity, Judge Jack's appointment is still pending, is it not?
It would be.
And then we go back to where the statute tells us happens if the Senate fails to act within 60 days. That 60 days doesn't expire until next Tuesday, right?
Correct.
It's not an accident they put Tuesday down as the day they would come back. That was 60 days, the end of their 60 days, right?
Sure. I think the best answer that I could give is that it would solve some problems. It wouldn't solve all of them. But
it might solve all the problems we'd actually have in this case, right? And that's as far as we're supposed to go without issuing an advisory opinion.
Well, I'm going to struggle with this a little bit, but I think that in mandamus, or in exercising this court's original jurisdiction, one of the questions that the court is supposed to ask is, will this avoid the necessity of future litigation or of further appeals for the court to act? And this would certainly do that here.
That one decision would, wouldn't it?
It potentially could. Now, not knowing what the future then holds, there could be other questions that would arise due to timing issues and things like that. But I think,
sure.
Yeah.
But those are dependent upon the occurrence of future events that we're not talking about. In this case, as it sits before us today, the one decision you all need to hear an answer on is whether the withdrawal was effective. Because if the answer to that question is no, it was not, then everybody just goes back and plays ball under the provisions that are clear, right?
Yes, that would be true.
Why didn't the governor fail to make an appointment within 60 days? If you look at kind of a definition of failure, it fails to achieve its desired end, its purpose. why didn't she fail that, and then it reverts to the Chief Justice as the Senate maintains? Why doesn't that circumstance happen here?
Because failure there is about failure to make an appointment. It's not failure to ultimately have the judge be seated on the Court of Appeals. So that's the only failure that happened here. But the appointment was made. The parties, not all the parties, the Attorney General and the Governor agree that all the Governor has to do to avoid kicking it to the Chief Justice is make the appointment. She did not fail to make the appointment within that 60-day window. She delivered it to the Senate. And there's nothing else that she can do. So I think if we were going to read in an additional requirement of meaning that the appointment not only had to be made, but then had to ultimately result in the judge being seated on the court, then we'd be
Or at
talking
least
about,
the Senate voting on it.
sure, or that would another instance of reading something else into what you would have to do. But the statute is pretty plain. You just have to make the appointment. She made the appointment. The statute is also plain that just making an appointment is different from the appointment ultimately proceeding to a judge being seated on the Court of Appeals.
Well, the way the plain language is under A6, if there's a vacancy, appointment shall be effective at the time it's made, and then under B, no person appointed shall assume the duties until the affirmative vote of a majority of the members. So we do have an appointment, but we don't have the assumption of duties until something else happens.
Correct. I think that's exactly the right way to read the statute, that the subsection B is about the process that an appointee has to go through in order to be able to assume the office of judge of the Court of Appeals. That's also why in subsection B, where we have some language that maybe isn't as clear about who has authority, because it's so process-focused and it's so Senate-focused, we really ought to be looking at subsection A. And subsection A makes abundantly clear that it's the governor who is supposed to be making these appointments, unless the governor chooses not to act and thereby fails to even make an appointment.
Doesn't that argument by implication suggest that the legislature intended, as Justice Biles was suggesting earlier, that there is no possibility of withdrawal for this particular office? Because that would actually make the statute work exactly the way you're describing it. The governor properly exercises her authority within the 60 days. If that nomination fails for any reason, it's very clear the governor gets a second 60 days.
I think it would work if that were true. The presence of 754315B really, I think, tells us that if the legislature intended for the governor not to be able to withdraw, we'd see that laid out in the statute somewhere.
But maybe the reason that's not there is because of A6 and because of your argument. Your argument was once the governor makes the appointment, there's nothing else left for her to do until the Senate acts. And if that's the case, then what's she doing coming back in and withdrawing when the legislature didn't provide for it? It provided for, she was done when the appointment became effective.
Right. I think she's doing two things in that scenario. One, she's exercising the clear authority that 754315B gives her. And two, she's also doing the right thing. In a context like this where the appointment pending in the Senate would just create confusion or a wasteful process for Senate confirmation that serves nobody's interest, withdrawing the appointment is the right thing to do.
What if the Senate disagreed with her? What if she made the determination, oh, I made a mistake, this isn't an appropriate person to fulfill that position, but a majority of the Senate goes, no, we kind of like the guy.
Well, the law is what the law is. I mean, they can change the law for the next appointment.
But you're
I
making the
suppose.
policy argument that this would be a waste of time and money and a futile effort, but not if the Senate were of a mind to approve that person. It wouldn't be wasteful, would it? It would be contrary to what the governor decided she wanted to do later, a change of mind, but not every case is necessarily one in which the Senate would agree with the governor's assessment, right?
Correct, and that may occur. It's not what occurred here. I mean, we had very clear indication from the Senate President and others in the legislature.
we don't-
We don't make ad hoc interpretations or constructions of statutes, because that's a legal question, not a factual question, right?
Sure, and the parties aren't asking for any ad hoc decision. I mean, the parties are asking for the statute to be interpreted, and to have an interpretation that addresses whether it allows for withdrawal in the first place. The legislature has a specific statute that allows for it. The parties agree that authority was exercised here. The question now is Sarah Warner's appointment to the Court of Appeals effective and pending in the Senate? And I see my time is out. I would just ask the court to hold that it is.
Let me ask you about that, because I've been struggling with that a little bit. Assume with me that we hold that Judge Jack's appointment is still over on the third floor of the Capitol. Once we getting this kind of goes to Justice Byers' question. Once we decide that, do we have to say anything about the Sarah Warner appointment from your standpoint?
I don't know that you have to say anything about the Sarah Warner appointment at that point. I think it would be, we'd move on to the next step in the process. I think that there would still be a cloud over whatever appointment came next, because the question would be, did the Senate do anything at all when it voted on something on May 14th?
Well, we answered, I'm saying, assume with me we answered that question.
Mm-hmm.
And so that the Jack appointment is still with the state Senate. And so it does whatever it wants to do on Tuesday. Is there anything we have to follow? I mean, the general told me that if I dismiss, then there's this legal question about if they vote, did they really vote on anything? And so, okay, fine. There's an answer there. I'm not sure I believe it, but there's an answer. But how about on this second appointment business?
Okay. Yeah, I don't think the court would need to say anything other than the withdrawal was not effective and the Jack appointment is still pending in the Senate. Now, I will just reiterate that I don't think that that's a valid reading of the law in this situation. Any reasonable interpretation of the governor's letter to the Senate Majority Leader is that the appointment was withdrawn and it's no longer.
Wouldn't we also have to say that the Warner nomination was not lawfully effective or legally effective? I mean, otherwise you got competing nominations. What if the Senate said, well, we're going to confirm Sarah Warner?
Right. I think that would be a sort of a necessary consequence, an unavoidable consequence of a holding that Judge Jack's appointment was still pending, would be that Sarah Warner's appointment was not valid at the time it was made.
At a minimum, it'd be premature pending
Right.
action, negative action on the Jack appointment.
Right. I don't think the court would actually have to hold that, but I think that would be a consequence of the court's holding.
It might be really the only act that was unauthorized that's appropriately under a quo warranto statute.
Under that approach, yes.
Okay.
I think that would be true.
One more question. If we did, as Justice Biles has suggested, a possibility, just dismiss this matter without answering any of the questions, and the Senate fails to act on May 14th or 15th or what have you, then what would happen in your view? Would anyone be on the Court of Appeals in Judge McEnany's seat?
I think that is exactly the circumstance that we're all hoping to avoid, because we don't know what happens then. That's why mandamus jurisdiction exists. That's why we're asking the court to come in and give that interpretation for the guidance of public officials in executing their duty. Thank you.
Thank you. Mr. Pigg?
Thank you, Your Honor. Steve Pigg for Chief Justice Nuss. Chief Justice Nuss declines to advocate a position, and accordingly we waive any argument.
Thank you.
Thank you.
Your Honor, may it please the court, Jeff King on behalf of the Kansas Senate. Given the discussion, very lively and helpful discussion with the court. I'd like to start expressing my appreciation and that of the Senate for the court's expedited schedule in considering this. The 40 members of the Kansas Senate have done their work in the regular and veto session and are eagerly awaiting the decision of this body to figure out whether they need to convene again on May 14th to consider the nomination of Judge Jack.
Why isn't
Mr.
that
King.
just an advisory
Excuse me.
opinion? It seems like the Senate's asking us to just answer a question. Instead of, I just don't get it, as to the Senate.
I don't believe for the Senate or for the state as a whole that the first phase of this discussion is an advisory opinion. I'm segregate the two phases, looking at 75-4315B as to whether that applies and whether Governor Kelly's withdrawal of Judge Jack's nomination is effective. And then we have more of the merits in the second part.
But we can decide the withdrawal question with just the state and the governor. We don't need the state Senate to answer any of these questions, do we?
The state Senate is directly and immediately impacted by the answer of that question, Your Honor. And in fact, I would say that the state Senate is the reason that the expedited nature of this proceeding was so important, and why I was expressing, particularly on behalf of the Senate, my appreciation for it. If the interpretation that I hear you forwarding, Justice, that the KSA 20-30-20 as the specific statute supersedes 75-4315B and it takes away the right of the governor to withdraw a nominee in a Court of Appeals instance, or as well in Justice Stiegel's example, if 4315B applies, but the method of withdrawal exercised by Governor Kelly is insufficient, if either of those instances hold and this court finds them, then the Senate is compelled by May 14th to either act on the nomination of Judge Jack or let that nomination go into effect by its inaction. If, however, the view that the Senate articulates this court should take, in that while 20-30-20 is a specific statute, it is silent and does not cover the field encompassed by the withdrawal of a gubernatorial nominee, that field being taken by the more general statute of 75-4315B. If that view is taken by this court, then we know the withdrawal is valid, and the determination comes to the second point, which also directly impacts the Senate on whose nomination does the Senate consider. Does it consider Sarah Warner as nominated by the governor? Need it wait for the Chief Justice to make a nomination? Or does no one have this authority, as the Attorney General argues? That question directly and specifically impacts the Senate in a unique way.
Counsel, I have a quick follow-up. I'll apologize in advance. This may seem like it comes out of left field, but both your co-counsel have referenced the position of the Senate. And in your answer you just gave, you talked about the position of the Senate. And I'm struggling, I guess this is the question, how do we know what the quote-unquote position of the Senate is on any of these questions?
As an administrative, the position on the Senate as a nominee, on a nominee, the position of the Senate on
the
the
legal
vote.
position, the Senate's taking legal positions and factual positions. I'm
In
just
this case.
in
this
this,
case,
yeah.
yes.
How do we know? Typically, we don't look behind legislative acts of a legislative body, and we don't have a legislative act here. We have 40 individual state senators, and I'm struggling to see where we achieve, or where we find their consensus view on these contested issues.
And my apology, Justice, I was being too circuitous to get to my answer. Saying on voting policy matters, it needs 21 members of the Senate to approve. The administrative matters of the Senate, who represents the Senate, the right of the Senate to retain counsel, for instance, is covered by the Senate rules being approved by the majority of the body of the Senate at the beginning of each biennium, and vests that authority specifically with the office of the Senate President.
What rule is that?
I the general rule on the authority of the
I mean,
president.
you told us that the Senate President consented to being a participant in this lawsuit and didn't care about immunity for these purposes and that sort of thing, but you didn't cite any authority for the Senate President to be able to do that. And so that, I think that's part, and that's going to relate to the whole capacity question, which I think is a big one here with this body because of the Stephan House of Representatives case. So let's start with what's the authority for the Senate President to be able to waive immunity, participate in lawsuits, consent to facts. When I look at the Legislative Council statute, and you're not Legislative Council, right?
Not retained directly under the
Under that
Legislative Council.
statute.
That requires Legislative Coordinating Council.
Right, but it also talks about a resolution of the body in order to go forward, and you don't have that. So I'm just, what can I look to find the authority of the Senate President to make all the concessions that you made in your responsive brief?
You know, specifically Senate Rule 55 we cited involves the authority of the Senate to expedite and to handle specifically the details of appointment procedures. When it comes to the actual part of the Senate rules that grants administrative authority, I don't know that off the top of my head. I can certainly provide that.
Is it fair to say that participation in a lawsuit is an administrative function? I'm just thinking, like, what if 35 senators said, well, we don't agree that we ever received this nomination? And I know that's out, that's not the case here. It's a hypothetical, but I'm just grappling with the same problem Justice Biles is describing, which is, how does the Senate President speak on behalf of the Senate?
Well, again, on this, I apologize. The question is not out of left field, but I didn't come armed with specific number and letter references from the Senate rules on it. The example that you give, the Senate Majority Leader is vested with oversight authority on appointments, particularly chairs the Confirmation Oversight Committee, as vested with that authority by the Senate rules, and the notification specifically was given in the manner directed by the office of the Senate Majority Leader. So on that specific issue, the factual consent that you're referencing fell within the purview of the Senate Majority Leader's office to give. If you're talking about broader administrative authority, the ability to retain counsel on behalf of the Senate as part of President Weigel's administrative authority over the Senate, I apologize, I don't have a specific
Does the struggle there weigh on the legal question as to whether or not the Senate is a proper party in this action? It seems to me it has to.
If the question of whether the Senate is a proper party comes down to whether the Senate, considering that this lawsuit commenced during a recess and then during the veto session of the Senate, the question comes down to whether the Senate has the power to waive its immunity from suit during or within 15 days after the legislative session under the speech and debate clause, whether the Senate President has the authority to make that decision on behalf of the Senate without a resolution. That would fall to the court's interpretation of the power vested in her by the Senate rules.
Mr. King, just going back to a scenario that I think is factually could be the case here, and that's the trouble it could be. The governor makes the appointment, which we all agree. Judge Jack withdrew his nomination, said, I don't want to be considered. And for whatever reason, he withdrew it. Is the Senate required to go through an act of futility to vote on that issue? We no longer have that. I mean, the statute's silent as to whether or not the governor can do this, arguably. But what about the appointee, a nonpartisan appointee? Does the statute have to fill in that void, or can that appointee withdraw? Again, for any reason other than a coerced reason.
The statute,
a criminally coerced reason.
Assuming absence of a coercive reason, the statute does not envision nor have I seen any statutory authority granting the nominee the power to withdraw. Obviously, the nominee cannot be compelled to participate. So the nominee could not show up at his or her confirmation hearing, not attend the vote, and could immediately resign office upon receiving confirmation if that occurred. But I see no statutory authority allowing the nominee on their own to withdraw that nomination.
That's not under 75-4315. It has to be the appointing authority.
It has to be the appointing authority under that
I have a
statute.
couple quick questions for you.
Certainly.
And again, this is just to clarify, because when I read the stipulated facts, I don't get a satisfactory answer yet. Is the Senate, assuming the Senate can have a position that's taken by, assuming all those questions my colleagues asked just a moment ago are answered in the affirmative. So is the Senate disputing that the governor made an appointment, as the phrase "make the appointment within 60 days" in A4 reads? Is it disputing that she made the appointment of Judge Jack on the 60th day?
And in all of the answers on behalf of the Senate, I want to make sure the record is clear given the questions raised. That is done under the authority of the President of the Senate, so I'm answering on behalf of the Senate President in this regard. There is no question that was made, that the governor made the appointment within 60 days.
Okay. And is it disputing that the Senate received that appointment on the 60th day? That's another part of the statute that talks about Senate receipt of the appointment. Is it disputing that?
It is not. The Senate is not disputing that the majority leader, who is invested by Senate rules with overseeing the confirmation process, received it in 60 days.
Are you disputing that that's adequate to be receipt by the Senate of the appointment under the statute?
We are not disputing that is adequate. If the court, and the only reason I'm providing any caveat, and I do apologize, Justice.
I'm really just trying to understand your position.
The Attorney General makes a point that the nomination was never read into the Senate.
I saw that.
The Senate does not believe that for purposes of satisfying the 60-day requirement, the reading in of the appointment is necessary. Okay. The Senate also understands that that's a legal question and that that's not a factual question, and the Senate is not trying to make that determination of law, but it's the Senate's position that it was received for purposes of the statute.
Made by the governor, received by the Senate on the 60th day. Is the Senate disputing that the governor attempted to withdraw the appointment on the 63rd or 64th day, depending on whether it's
No,
Jack's letter?
that's not disputed.
Okay.
Well, let me dig into that a little bit. Again, there's a difference between the underlying facts and the legal effect of those facts, right? My understanding of the stipulation is everyone's stipulating to what was actually said.
Precisely.
And that's what we know. But whether or not, is it a fact question, whether or not that's an attempted withdrawal?
I think it is
Or is that a legal question?
The effect of the attempted withdrawal is most certainly a legal question. And I have, certainly legal arguments I would make in that regard, but it is a question of law, not one of fact. Whether the governor attempted to effectuate such a withdrawal, I believe is a facts question that the Senate is not disputing.
Why couldn't on these stipulated facts it be just as reasonable to conclude that the governor was just simply transmitting Judge Jack's withdrawal of his own name from consideration? That's the more reasonable reading of this language that everyone's stipulated to.
Your Honor, I would respectfully disagree with that reading in the sense the governor requested the nominee to withdraw. At that point, of course, the nominee had two choices. The nominee could say, thanks, but no thanks, I'd like to stick this out, or I will accede to your request. The governor takes Judge Jack made the latter choice. The governor takes Jack acceding to her request and tells the Senate, Judge Jack wishes to withdraw his nomination. I'm appointing someone within 60 days. If the governor did not want to withdraw Judge Jack's appointment,
that's where I'm hung up. I just see nothing in these stipulated facts that suggests that the governor wanted to herself withdraw the nomination. I just don't see it. So if you can point me to it, that'd be great.
I think the distinction that is the difference in this, Your Honor, is the fact that Judge Jack did not withdraw his appointment directly to the Senate, but the governor did. I agree completely, Your Honor, that if Judge Jack had sent a letter to the Senate, that would be ineffective.
I think both happened, right? Jack did send a letter to the Senate, and then Governor Kelly also sent a letter.
And his letter was ineffective to effectuate withdrawal under 754315B. Her then forwarding that letter, especially considering that he had already forwarded it, was either an act with no purpose, or it was her effectuating her own desire that this situation occur.
Okay.
The position of the Senate is on what I'll call the merits of the issue, the second point, very similar to that of the state with one very crucial exception. The Senate very much does not want this court to write law where none exists. We appreciate the reticence of this court to do that and encourage the court to follow that procedure. However, the Senate doesn't think a gap exists in the statute. And specifically in briefing and here, direct the court to the same language Justice Rosen mentioned of what is the failure of the governor to make the appointment within 60 days. Going to a point raised by Justice Johnston.
Your point is that if it's withdrawn, it was never made.
It was
in a debate. Just get down to that.
It was effectively abandoned.
As a matter of law.
Yeah,
because factually it happened.
Right.
Yes.
Right.
But as a matter of law, correct.
To get there, do we have to ignore A6 and that language about the appointment shall be effective at the time it is made? If it's effective, it's effective, right? So how has it failed if it's effective?
It's failed in the sense, and I would like to draw off of Justice Johnston's arguments and continue them, in the sense that I think it all depends on how this court interprets 4315B. Because if the court interprets 4315B to mean the governor has no withdrawal authority for a Court of Appeals appointment, then absolutely you have an instance where once the nomination is made, to quote the justice, the governor's hands are tied. Governor's out, steps back, it's in the Senate's court. The Senate is the only body that can do anything. Even if the nominee withdraws, forget the governor. If the nominee withdraws, there's no statutory authority for that. I think the process has to continue through.
And your position is there has to be statutory authority before a person appointed to a nonpartisan position withdraws. What happens if the person passes away? Does the Senate still have to act on that?
Then the Senate would have to recognize the inability of the person, obviously, to fill the appointment, restarting the clock.
I apologize.
Not at all.
Well, and there's a pretty clear analogy there to elected offices. We've had political candidates who've passed away near to an election who have been elected to office from the grave.
And then the statute allows for
and then there's a vacancy immediately, essentially.
Precisely.
Isn't that scenario the one that makes the most sense out of this statute? That there just isn't a mechanism for withdrawal period? Because then the statute becomes a self-contained whole. It covers 100% of the ground, doesn't it?
If there's no authority to withdraw.
Right.
I believe you're correct. And that was sort of I certainly want to finish answering your question, Justice Lukert. That was my point. If, conversely, 754315B authorizes withdrawal, which for the reasons stated in our brief, we think it does, then in that instance, you have empowered the governor to actually take actions contrary to A6 to abandon her own appointment. And if the governor has the authority to forward and then abandon her own appointment, that has to be a failure, both under the definitions that we gave you for failure in A4, and to make the statute then work in harmony. There are two ways it works in harmony. Justice Stegall provided one way. The other is abandonment through withdrawal of a nomination results in a failure under A4, Because if it doesn't, the 60-day rule has absolutely no effect whatsoever. And the 60-day rule has been effective for decades in a variety of contexts.
Well, it could have the effect the Attorney General advocates, which is to create a vacancy with no statutory mechanism for its filling.
And, Your Honor, if this court, using tools of statutory interpretation and construction, reading the statutes that are in play today together, believes that the language that I cited is not reasonably available to the interpretation I provided, then we agree with the Attorney General.
I want to clarify your concession. If the interpretation is that there is no statutory authority to withdraw the nomination by either the nominee or the governor, and if an incapacity or death occurs, that doesn't withdraw the nomination, that there is no gap in the statute. That's what I heard you say. Is that correct? Is that your position?
The Senate believes there is no gap in the statute at all, but under the circumstances that Your Honor just stated, you are correct. The Senate believes there's no gap.
And isn't that the touchstone of statutory construction for us to give effect to legislative intent and purpose? And this is a statute whose purpose is to provide for the filling of a vacancy in the Court of Appeals. And why shouldn't we construe it to give full effect to that purpose without leaving gaps by construing silence? Isn't that our goal? Is our number one touchstone is to give effect to legislative intent, right?
Your Honor, I agree with you entirely. Certainly that this court has stated many, many times that the greatest indicator of intent is the plain language of the statute interpreted through statutory interpretation and construction tools used by this court. I believe that with the definition of failure in the language of A4, that whether the withdrawal statute is authorized here or not, that there is no gap in the statute. But certainly if this court construes 4315B to not allow withdrawal, then there is no gap in the statute
What
whatsoever.
about the other language in A4? The failure has to occur within 60 days. And I thought you and I had already established that the Senate's position was that she made an appointment within 60 days.
The Senate.
And just so we're clear, not only the facts that back that up, but you're conceding a legal issue. You're saying she made the appointment in 60 days. Maybe we didn't communicate adequately. I want to make sure we did.
And if we didn't, that's certainly my apology for that, Your Honor. The appointment was delivered within 60 days. There's no question that the appointment wasn't delivered. To me, there's a legal question on if an appointment is delivered and that appointment is abandoned by the same appointing authority that made it
After the 60
after
days.
the 60-day period.
That's the
then
same
is
as
that,
failing within the 60 days?
That's correct.
Okay.
So it
Just wanna make sure I
retroactively,
understood what you meant.
I'm sorry,
That's okay. I'm done.
it retroactively extinguishes the appointment, is what you're saying. Even though it was effective immediately, that effectiveness was retroactively negated by a subsequent abandonment. That's your interpretation?
It was consensually abandoned by the governor, is our interpretation. Your Honor, this is probably a too simplistic of an analogy, but I would equate it to if someone is contractually bound to make a payment, to deliver a check within 30 days, they deliver the check on the 30th day and stop payment on it on the 31st. Did they ever actually effectively deliver a check in 30 days? I think the law would maintain that they did not, and we're claiming that an analogous situation happened here.
Further questions? Thank you, Mr. King.
Thank you, Your Honor.
General Schmidt, you reserve 4 minutes.
Well, thank you, Your Honors. Might just attempt to address some of the issues that have been raised. Obviously, it's a broad scope of matters presented to the court here. I jotted 4 points that I thought were worth hitting. Number one, I've been thinking a little bit more about Justice Biles' point with respect to quo warranto, or whether there's actually a dispute. And beyond what I previously said, I would just make 2 points. Number one, I think this court's case law does suggest that quo warranto, like mandamus, is suitable as a vehicle to get answers from the court for the purpose of providing guidance to public officials in their duties. And number two, on that point, certainly in addition to everything else that's been discussed, I don't think there would be a dispute that there was a live exercise of authority with respect to the withdrawal of the Jack nomination. The governor's purporting to withdraw, or allowing the withdrawal, or however one chooses to characterize it here. And that certainly did occur. So to the extent the court reaches the issue of the withdrawal, I think that is certainly properly in front of the court, even with questions that have been raised otherwise. Number two, on reflecting on the arguments, I think the state's position is that in the event this court were to find that Judge Jack's nomination remains pending before the Senate and has not been withdrawn, in the event that is the holding of the court, and assuming that happens in time for the Senate to take an action by the 14th, that does resolve the remaining ambiguities that have been presented. Doesn't mean others won't arise, but in that event, I think we are then back within the statutory timelines as they're constructed by the plain text of the statute. In the event, however, that the court does...
Let me interrupt you real quick on that second point. To answer the withdrawal question, we would need to both look at the Court of Appeals appointment statute and the general statute, right?
Well, that's what the state thinks.
There isn't anything, I guess I'm asking, yeah. There isn't anything else?
I'm not aware of anything else. Okay. That is correct.
And does it matter if the withdrawal is as a result of, as it was here, kind of a voluntary, I don't want to seek it anymore, or whatever, or if it's an involuntary incapacity of some sort? Would that matter?
I don't think as a general matter it does, Your Honor. I don't want to go too far down this trail, but the death scenario, for example, right. Obviously that does happen. The example Justice Stegall raised is one that we were prepared to suggest, that while unfortunate, that does happen in the election context.
But in this context, if someone died or became incapable of serving the position, would we be in your limbo land where there's nothing anyone can do?
I think
after the 60th day.
I think the answer to that is yes, which is, in the state's view, yet another reason the legislature and the governor in their lawmaking capacities need to fill these gaps. And I would add just a legal fact, not of the case, but of the statutes on that. We did take a look at the statutes that govern withdrawal from district courts in a nominating district, from the Supreme Court in the nominating posture, and of the Court of Appeals prior to those statutes' repeal in this bill.
And took that into account.
And they all expressly talk about death. Likewise, in the election law chapter, there's a subparagraph that expressly talks, so the legislature knows how to talk about death. They chose not to here, so we think and they didn't talk about that here either. In the four corners of this statute, we think they did in the other read together, but nonetheless, they didn't talk about it here, so agreed. The third point, we didn't talk a lot during my initial presentation on the state's interpretation on what I'll call the merits beyond the issue of whether the Jack appointment were still pending. The governor and the Senate did talk a bit about that. I won't belabor it, but I do just want to maybe get to the peanut of why, in our view, there is no operative language in 3020 that in the event Judge Jack's nomination is not still pending and that it was withdrawn after the 60th day, we think there is no operative language that allows for this subsequent appointment by the governor. We don't think you can simply read A alone and ignore the language in B. Obviously, the legislature granted things in A, but it constrained them with the limitations in B, so you have to read them together. And I think it's the fourth sentence in subsection B that is most at issue here. That's the sentence that talks about if majority does not vote or consent, whatever it is, then the governor, within 60 days after the failed Senate vote, shall appoint again. And we just think the plain reading of that statute is, of that phrase, is that the sentence talks about a circumstance where there was a vote. That didn't happen here. And we think that for two reasons. One, because it has that phrase in there after the failed Senate vote, and two, because the subject of the overall sentence is majority, not Senate. If a majority of the Senate does not vote.
General, just one clarification on your point. If the governor would have made this appointment, say within the 10th day, not the 60th day, and then all this happened within the next 20 days, whomever withdrew, what's your position there about the governor making another appointment?
Right, we've thought quite a bit about that hypothetical, and I think that in that case, the second appointment would be authorized by the governor.
So it's a time period.
But not authorized by the language in B. It would be authorized still by the language in A4, because we are still within the 60 days from the date of the vacancy.
So in order to be authorized, it would have to fall in that first 60.
That's what we believe. Yeah. Or it has to have triggered the provision in B that allows a second appointment, which hasn't happened here, which is why we've reached the conclusion that there simply is no language here that provided for this circumstance. And I might note that to the extent one is tempted to read that language in B that we're talking about, the fourth sentence, read it in a way that effectively reads out the language between the commas or focuses on that language of the majority does not vote to consent. That's really not particularly helpful to getting clarity in the statute, because if one reads that sentence so broadly that vote not to consent is what happened here, well, then what happened here is also that the Senate failed to vote, and the language in the seventh sentence is triggered, and now you have two conflicting statutory commands on what to do. So that's not particularly helpful, we think. And finally, we don't think that you reach the legislative intent analysis. I know there's been some probing on that, and that's obviously something the court will decide if it reaches the issue, because we think the statute, while it's got a hole in it, it's plain. It just didn't contemplate this circumstance. It's not ambiguous. It's that the legislature provided for a number of specific situations, didn't provide for this one, could have, knew that there were issues of withdrawal, it repealed language related to withdrawal, knew that people could die, it's done it in other contexts, chose not to deal with it. And the problem, so we don't think you reach construction, but in the event that you do reach statutory construction, I would just offer this sort of in furtherance of Justice Johnson's line of questioning. Yes, of course, the overall purpose of this statute on a broad policy level is to provide a mechanism to fill vacancies on the Court of Appeals. That is a true statement. But it's also true that the statute does more than that. And part of the overall purpose of the statute, it was to increase the role of the governor in the process, the discretion, that was argued by the governor, it's in the briefs. It was to inject and therefore increase from zero the role of the Senate in the process compared with the prior system. And it was to constrain both of those actors in how they exercise and meet their duties under the statute. Time limits, default consequences of the authority shifting to the chief, that sort of thing. So I don't think it's enough simply to say the statute's intended to fill a vacancy. The legislature didn't tell us how to fill this vacancy, therefore we must find a way from this court to fill the vacancy. There are competing interests that's illustrated by the governor and the Senate having obviously competing views on what should be done here. If the court reaches those questions, we would urge that the court simply show restraint and find, as a matter of judicial review, this statute doesn't answer the question that's arisen because we've gone down this dead-end path, and only the bodies that created the law can tell us how it's supposed to be resolved. With that, I'd either stand for questions or sit down.
I have one question, and you may not have a position on this, but as a former member of the Kansas Senate and now Attorney General, do you have a position on the questions I asked the Senate's counsel earlier about whether or not the Senate is a proper party, and if it is, how does a body like the Senate express its view in the course of litigation?
Right. Justice Stegall, I'd like to answer that be glad to answer the question. I'd like to answer it, however, from the vantage point of my current capacity as Attorney General. I don't think it's appropriate for me to speak or speculate on what the Senate might do. From my vantage point, this is a very odd lawsuit, obviously. The state is suing its governor, its chief justice, and its Senate. I recognize that it's peculiar. So it raises a number of issues that are, shall we say, not common before the court. Obviously, there are issues related both to amenability to suit and to legislative immunity under Article 2, Section 22 for the Senate. State's vantage point is we have presented a proper lawsuit. We have properly served and given process to the Senate. We have provided this court in the briefings with, we believe, sound legal reasons why the Senate is both amenable to suit and is not shielded by legislative privilege in this circumstance. And if the Senate wants to dispute that, that is for the Senate to decide as an internal matter how they go about doing it and
So
who does it.
you're taking probably the wise course in declining to answer the second part of my question,
Remaining
which is
agnostic.
how the Senate would express its views in the course of litigation.
Agreed. I just don't think it's for either the Attorney General or candidly and respectfully this court to look behind what the Senate's done. They've showed up here, they've participated as a defendant, they've represented through counsel that they've waived, and if there are any issues with that, it's not an issue for you or me, it's an issue for the Senate.
Well, General, don't you, I mean, that's where I've got to kick back. We have an obligation to make sure we have jurisdiction, you know, the proper controversy here. I mean, there are a lot of pressures on us, which we even have the ability to raise sua sponte, in order to make sure that this litigation is properly poised. Because otherwise, you know, we're into the dangerous ground of it giving advisory opinions. And I've said that 6 or 7 times, but you guys are really on the line here. You probably have a little chalk on your shoe with this one. And I think we've got to be able to probe this, and unfortunately we're trying to probe it, you know, at 150 miles an hour and trying to decide this case on an expedited basis. And so, to me, that counsels the way this court dealt with the Stephan House of Representatives case, even though I was where you were. I didn't argue that case, but I was on it. And, you know, the Supreme Court said, these are some real hot issues regarding whether bodies of the legislature can be litigants, and really the best thing for us to do in this case, in this original action, is to just dismiss them and kind of not resolve it. And that's looking awfully attractive.
Well,
particularly at 3:45 on Thursday afternoon.
And also 3:45 out here, Your Honor, so I don't want to prolong this, but since you raised the question, maybe just 2 thoughts on that. One, from the state's vantage point, we do think the Senate is properly in the lawsuit on the face of the pleadings, and to look beyond that, so that's enough for the court. And to look beyond that, you know, the Senate didn't raise those issues. Having said that, as in Stephan, in the event that the court were to dismiss the legislative body, although I don't think you should here, but in the event where you still can reach the same issues with the parties that are still before you, I believe that's what happened in Stephan.
Yes.
But number 2, a fundamental difference, and the last point on that, the fundamental difference here is that in Stephan versus House of Representatives, the legislative bodies, I believe both the House and the Senate were separately in that case, if memory serves me. But they were represented by legislative counsel, and they advanced these arguments as to their amenability to suit and to their immunity. Here, it's different. The Senate's here, or at least on its face, the Senate's here.
Or at least the
That's
Senate
enough.
President's here. I mean,
And those arguments are, the Senate was properly served, at least under the Stephan rules. So, in any event, that's what we think. With that, Your Honors, thank you for your expedited consideration on this. The state's very grateful for whatever clarity the court can provide.
Thank you, counsel. We obviously understand the expedited nature and will continue to treat the case in that manner, but we take this matter under advisement.